Teenagers and cell phones, hey, they seem to go together like peanut butter and jelly. What happens if a kid takes a cell phone to school that says, oh, you can't have cell phones here? Well, that takes us to this week's case. Involves a real student in Kentucky. He was in high school. And there, well, lo and behold, surprises of surprises, he was using his cell phone to send a text while in class. Teacher saw this, went over, confiscated the cell phone. And then the teacher began to look at the various texts to see what was going on here. Later, the teacher said the reason the teacher was looking at the text was because there was a concern the student might be suicidal, or more importantly, that the student was involved in dealing in drugs. And I say more importantly because that's something that could have been stopped right then and there. Okay, well, the case went to court, eventually found its way up to the Sixth Circuit Court of Appeals on the federal level. And there the court took a look at the case and at the facts. They said, well, here we have a rule and the school prevents use of cell phones in class. That's a reasonable rule. That's a reasonable rule. Okay, but when the cell phone is confiscated from the student who's using it in class, can the teacher or administration look at what's in the cell phone? And there the court came away saying, no, no, no. The administrators, the teachers, cannot begin to immediately look at that content in the cell phone, because to do so is a violation of the Fourth Amendment. Fourth Amendment says government cannot engage in unreasonable searches and seizures. In this instance, it's the search of information that's held by a private citizen. The government, of course, is the school. It was a public school. So, in view of that, it was found that there had been an unreasonable search and seizure. Now, the courts recognize that use of cell phones in school are a little different than, frankly, some things that go on in the rest of society. First of all, the majority of students are under 18 years of age. They're minors. They're not adults. But they still have rights. They still have rights under the U.S. Constitution. Now, the school may say, and may have a rule that say, no cell phones are allowed on this campus at all. That's a legitimate rule. And therefore, no cell phones can be on campus. If a kid brings a cell phone onto the campus and the school becomes aware of it, the school, in many instances, can confiscate that cell phone. However, as we've seen in this case, and as we see in some other cases, the administration and the teachers cannot look into that cell phone and find out what information is there, because to do so is an unreasonable search and seizure. What the school has to do is show that the search was justified at the time it began, at the inception of the search, and that the basic scope of the search was reasonable, was just confined to a reasonable basis. Now, this is not as high a standard as basically you must show that it was a reasonable search and that there was justifiable, reasonable basis for doing the search, the kind of test that exists for police officers. It's a little different test, it's a little lower. But nonetheless, there is that test there. And so once again, what do we learn from this? We learn that the U.S. Constitution provides very broad protections for the citizens of the United States of America. And those broad protections apply even to people who are under 18 years of age, and that they, in fact, can assert those rights. Okay, we bring you this case, we bring you cases every week so you understand how the law works. I'm David Allen.